Hello again, folks around the world. Thank you for tuning into IP and business in Europe. This is episode 3, where I will walk you through some IP rights, the most important IP rights, and give you some examples on what traps you may encounter if you want to make business in Europe and take not sufficiently attention to what is IP. So IP only in the sense of business owners. So I do not go into any technicalities of how to file and what kind of problems there exist. But I would rather like the business owner to have a general idea on what is ongoing and what are the traps, and maybe even lawyers will not get it at this point. And the impact can be very hard. So IP is global. The United Nations, they made the TRIPS agreement with the agreement of nations around the world, and they protect since 1990 or so all the IP rights around the world, with a member of the World Trade Organization. So this is something which is global. And if I talk about a patent, well, a patent is probably the same understanding in China as in Europe, as in the US, with some small adjustments with regard to the practice of the filing and so on. I will not go into these technicalities. As I say, I want the business owner to get some more information and to carry out its business, these small enterprises. This is, I'm very conscious that this is 99% of the European business, the backbone of the European business, not the multinationals, but the backbone of the European business. And I suppose that it is similar numbers and percentages around the world. So you are the important factor, driver of the European economy with your innovations, with your drive, with your spirit. Things move forward. So let me talk about a first example. A first example that would be a company, a startup. Let's think about a startup. A startup, a small company, somebody has the invention of doing a software, innovative product, and want to a fast drone or whatever, and can be at the level of development with some guys, 2, 3, 4 guys, I don't know. They are able to do something with a basic idea, and they move forward with complementarity of visions of the 3 or 4 founders. And well, guess what? At a certain moment, what happens is what always happens, that everything is too expensive, and we need to have some more money in order to go forward. Now, they may go to their parents, and the parents say, well, get this money, but you will probably not be very far unless you're a son of a billionaire. That would be easier. But if not, you may rely on a bank or on a venture capitalist, and the negotiations with these banks or venture capitalists that will go very early, in the very early stage, with the question, what do you have? And what do you have is, what intellectual property do you have? And it is not about a registration of an intellectual property. No, it is about of the moat that you may have over the competition. That is the question behind. They want to know how is your place within the economy, and how can you defend against imposters of that product you intend to launch. And if you can say, well, I have filed for a patent, that's okay. That is already something. If you don't have filed for a patent, then you should probably think of filing a partial patent. So you have done something, right? And something, if it is a software which has an industrial application behind, then you could file for a part of that future full patent, of the full product, which would be covered by a patent, you file a part of a patent and you can show something to the venture capitalist, which will be able then to give you some money in order to move to the next stage. Or you have already a product and you want to sell the product because you have a small business. You don't have distribution channels, you don't have marketing experience, you don't know exactly about what to comply with if you go to Europe, etc. Well, you may want to sell your product and move on to another idea which you already have made in your mind. So that is a possibility, but again, the same question for the potential buyer will arise. What will be the moat I will have when I buy your product? Well, it is just that. Or maybe a different situation. All of this happened in my experience, professional experience as a diplomat. I was in contact with many companies. What happens with a possibility I need another license from another company in order to complete my product? So I need a license because I can't use that technology as such because they have a patent on it. So if I need another license, then again, well, you make switch a change of license, of your partial license, of your license with the other. You give them and they give yours, and you don't need to buy that license, that patent or license from that patent, but you can use it without it. But you can use it only, you can negotiate in that way only if you have something, right? So that is all about. So in order to keep your business alive, you rely on what? You should know in the meantime, on the intellectual property. Now, let's move on to a second case. That would be, again, an Indian, an Argentina, and Latin American company who want to make its name on the European market. So, trademark, right? They want to have a trademark, and they want it for, I don't know, the beverages or a novelty gourmet product from Latin America, which is not known in Europe, and under that trademark. And they know already that they have to apply for a trademark, and they apply for whole Europe for this trademark. Okay, that is okay. Now, they make their marketing efforts. It is not that you send the product to Europe and everybody, although it has 600 million consumers, but a big portion of it will buy your product. No, even or especially when it is something which needs to be introduced to the consumers, which the consumers have not the habit to use. They need to get some, I don't know, influencers, Instagram. That is how it would go today. But still, it is based on some marketing effort which you have to do in order to get the consumers know your product. So this is money, and for a small enterprise as you, this money is scarce. But you are convinced that the effort is worthwhile, and you will come to the consumers and make business at the end. So, first you have a trademark, which is protected. Second, you have marketing effort. You have identified a distributor who can take care of the distribution of your products. And guess what? After a certain time, half a year or so, you receive three things: design and desist letter, cease and desist letter from a lawyer, an injunction from the judge prohibiting to use the trademark, and thirdly, probably cancellation request on the government agency where you have registered your trademark. And you happily will send them, well, I have a trademark registration, please have it here, so I'm okay, please take back, withdraw all your actions against me. But it's not as simple. Unfortunately, there was a similar trademark, or perhaps, well, a similar trademark, identical is not, but very similar trademark for food services as well, or food products as well. And the competitor has not made an opposition. You know, probably the trademark, there's an opposition phase, and then it's registered, right? And you thought, well, it's registered, so I'm okay. Nobody opposes it. And that one, they have probably slept over it. The 3 months period for the opposition, they didn't notice that you filed that application, and they didn't want to do something. And at a certain moment, they can file a cancellation request on the basis of the same claims as an opposition, on the similarity of the goods and services and the trademarks. And they did it. And now you are in a situation where you have to make a choice. Well, first thing would be, is it really similar? The goods and services, the trademark, is it similar? If not, well, you be quiet and you go on. If there's a similarity which is, well, you think a consumer could be confused on who is the real owner of the trademark, who is the origin company from this trademark, and they may be linked one to the other, well, then you may encounter a problem with regard to the government agency, which says, I cancel your trademark on the basis of the other trademark. On the injunction, you may not protest against the injunction, and the disease letter you might submit to them. So that would make all your marketing effort, I talk about a small enterprise here, for nothing. How does it feel? How does it feel now? Is intellectual property still interesting for your business? Or would you think intellectual property is something for, you know, the lawyers and the technicals, and they deal with it, and I keep my mind only on the business figures here? No, it is not. It is not. It is not. So you must have a certain idea of what will be the reaction of the competition with regard to your product. And what can be done here is, well, it's easy. 1 hour of the time of the CEO when you decide about the trademark. You can go into the register of the European Government Agency, and they have a register, a database, which is exploitable by yourself. You can do it, and you find, with artificial intelligence behind the database, you can find all similar trademarks, and you can assess yourself, well, I take this trademark because I think it's very interesting for the consumers, and I will be able to make it through any challenge I may encounter in the future. Or you can change, well, this is very similar, I will not get into that risk, so let me think of a different trademark in order to be sure, to play it safe. Well, that's what probably not happened in the first place and get you into all kind of troubles. Now, what can be done? Probably you change a bit your trademark in the sense not to making wrong with all the marketing efforts you have done. You change it and you get in agreement with that company that they say, well, this is now sufficiently different from ours, and you can move on with your trademark. Okay, so that was the second example, and I am now through with my time. I want to stick with the 15 minutes TED Talk, so I will leave it to a future video to give you perhaps another example and walk you to the other IPR rights which I have not mentioned today. So I'm looking forward to hear you again. The next video will be about some some government agencies, how to deal with them, and how you can do as a business owner do it. Thank you very much.